everyone. My name is Stefania. The purpose of this podcast is to discuss the topic of due process related to early steps. You may be wondering, what is a due process hearing? A due process hearing is an impartial procedure that resolves any disagreement related to any issues on the individual family support plan known as IFSP. Now, as a parent, you should be concerned about the purpose of the due process and why it matters to you. As a parent, you have the right to request a due process hearing if you disagree with the services and strategies that are written on your child's IFSP. You can write a letter to request a due process hearing to your local Early Steps or the Early Steps State Office at IDEA, Part C Coordinator, Florida Department of Health, Children's Medical Services, Early Steps State Office, 4052 Ball Cypress Way, capitalize BIN, hashtag capitalize A06, Tallahassee, Florida, 32399-1707. Just to let you know, if you send the written request, the local Early Steps will forward the letter within 24 hours to the Early Steps State Office. The following information must be written in your letter: the name and address of the child and parents, or legal guardians, the name and address of the local Early Steps or service provider against whom the complaint is made, a description of the nature of the complaint as it relates to the IFSP or the Early Steps records, a proposed resolution of the problem to the extent known and available to the party at the time, the signature of the parent requesting the due process hearing with the date of signing. After receiving your written due process request, the Early Steps State Office will send you information on the next steps, timelines, and schedule a resolution meeting, which is known as mediation. Now, let me explain what is mediation. Mediation is actually a separate meeting from the due process hearing. This is an informal meeting that may take place within 21 calendar days once the due process hearing request is received. Mediation is optional and voluntary. This meeting is meant to determine a resolution with the parents and Early Steps without having the due process hearing. If you decide to have the mediation, then you and Early Steps will have to sign the voluntary mediation request form. During the mediation, an impartial mediator who is knowledgeable in the laws and regulation related to Early Steps helps both the parents and Early Steps to a mutual satisfying agreement. Any agreement made during mediation will be placed in writing and signed by the parents, mediator, and Early Steps. All the decision will be kept confidential and will not be used in the due process hearing. However, if you do not want mediation or do not agree with the solution from the meeting and want to proceed to the due process hearing, then the local Early Steps will be in contact with Early Steps State Office to schedule a due process hearing. The date and time of the hearing will be based on your convenience. Now, you may be wondering, who will conduct the due process hearing? A due process hearing is conducted by an impartial person, a hearing officer from the Division of Administration Hearings, who is not an employee of either the local Early Steps or the Early Steps State Office. Their hearing officer will be knowledgeable of IDEA Part C and services available for eligible children and families, be able to have the ability to conduct a hearing and write decisions, be able to provide a record of the hearing and the writing decision, not have an interest that may conflict with the hearing officer's ability to be fair and impartial during the hearing. So, what are your rights as a parent during the due process hearing? As a parent, you have the right to be accompanied by counsel or by individuals who are knowledgeable of early intervention services for children eligible under IDEA Part C. Present evidence, question, and require the attendance of witnesses. Get a written or electronic word-for-word record of the hearing at no cost. Get written or electronic findings of fact and decisions at no cost. Open the hearing to the public upon request. The hearing is closed to the public unless the parties request that it can be open. The hearing officer will listen to the various viewpoints of the participants, examine all information related to the issues, and seek to reach a resolution for the issues at hand in the due process hearing. The written decision, the reasons for the decision, and a summary of the evidence will be mailed within 30 days of the due process hearing. Just to let you know that the decision made at the due process hearing is considered final. If you disagree with the due process hearing decision, you have the right to seek civil action in a state or district court. You have 90 days from the date of the decision to conduct a civil action. If you need further information, please refer to your Early Steps Summary of Family Rights document given to you by your service coordinator during your IFSP meeting, and a Parent's Guide to Understanding Due Process Hearing for Early Step, which is a brochure. Thank you for listening to this podcast. If you need further information, please contact your service coordinator.